A lot of athletes these days think they're above the law.
You're out of order! You're out of order! The whole trial is out of order!
Let's get an inside look at the legal side of sports.
One of my favorite segments of the week, Rick Calzada is our legal expert from My Law Solution over in Winter Park. Rick is my lawyer, so let My Law Solution be your law solution. Whether you're fighting the bank to save your home from foreclosure, whether you're a defendant in a criminal matter like a DUI or in need of a bankruptcy to protect your assets, My Law Solution does it all. Give them a call, 407-843-2222 or online at mylawsolution.com. Rick, I missed you last week when I was on vacation.
I'm so jealous. I haven't had my summer vacation yet.
Well, you're moving. So
that's true. Now
moving is no vacation, believe me.
We've made our move, and now we are in Baldwin Park, Florida.
So you're not in Winter Park anymore.
We are now in Baldwin Park, Florida.
I need to change my little thing here.
That's right.
Baldwin Park. All right. First, let's start with a listener question. We haven't done a listener question in a while, and I like this one being a divorcee myself, all right?
Ooh, I like this one, too.
This is from Larry. When I got divorced a couple of years ago, I agreed to pay my ex-wife $3,000 a month in alimony. Oh, he must make a lot of money. $3,000 a month in alimony based on the fact that I earn significantly more than her. Now she makes significantly more than me. Can I go back and renegotiate?
Fortunately, Florida has some of the most progressive alimony laws in the entire nation. All right. And so we have provisions within the Florida statutes which allow someone to modify alimony under certain circumstances.
Okay.
All right. So the circumstances have to be unexpected, involuntary, and a substantial change in those circumstances. And so an example would be where the payor has had substantial loss in income, not through anything he did voluntarily. So you can't quit your job making $200,000 a year.
Yeah.
Take a $40,000 a year job. Of course,
if you were to get fired from your job?
If you would be fired, but then you'd have to take additional steps to try to regain employment. All right. And so oftentimes there is an argument about whether it is voluntary, okay, whether it was unexpected. All right. But additionally, if now she is making substantially more money.
Yeah, she gets a really good job.
Correct. So
okay.
so we actually, under this fact pattern, we have both of the scenarios, one making more, one making less. Put them together, it sounds as if it is potentially modifiable. When I say potentially, sometimes in a marital settlement agreement, you can insert language that says the alimony is non-modifiable for its duration. And if that language is in there, there's nothing to do. He's stuck with it.
So could it be so modifiable that he could get alimony from her?
No.
Why not?
Because the alimony was awarded from one person to the other. You can't flip it on itself.
But the reason it was awarded from one person to the other is because the one person made significantly more.
Sorry. No, he can't flip
that
it in
is
his
such
favor.
a double standard.
But that was the agreement or the language in the final judgment. And so alimony just says one person pays to the other. Now, if there had been language in this that in the future, if she makes more money than I do, then I could ask for alimony from her. But I highly, highly doubt that they were so.
People should do that, though.
It's a potential way of seeing into the future and predicting something happening.
And even if it doesn't happen, at least you're protected if it does, right?
Yeah.
Oh, wow. What are you shaking your head for, Stedman? Huh?
I was just laughing at you because you were so adamant about. But
what? It's, never mind.
Don't protest too much.
All right. Tennessee settles a lawsuit. The University of Tennessee has settled a lawsuit. Has reached a financial settlement with a group of women who sued the school in federal court for the way Tennessee handled allegations of sexual assaults by football and basketball players. According to documents, the university will pay 8 women $2.48 million. This is one of those federal Title IX lawsuits. But here's the interesting part to me. Tennessee says they're not admitting guilt. This is just a financial thing instead of taking it to court and having to defend it, which would cost about $5 million. They're just going to pay the $2.5 million.
Standard.
Is it?
In any settlement, standard that.
So I shouldn't be cynical. They're just trying to bury this?
Not at all.
No?
Not at all. Although, in drawing from the earlier show, shame. Shame.
Yeah.
Right? Now, in reading the story, I had a thought. Okay. Is the university paying $2.5 million going to change the behavior of future football players? I don't think so. I
I also think there's some
educational.
Yeah, education.
Okay.
Yeah.
All right, please. Okay.
Talking about me being a cynic.
Okay, now I'm being cynical, okay? But if you really want to change behavior, why don't they hit the football program with the penalty, with the fine, with the payment? Why does it have to come out of the university's general fund? So there was a football player or two or three that were implicated. There were some basketball players.
Talking about hit the recruiting budget.
Hit the recruiting budget.
Yeah.
I guarantee
I like that.
I guarantee you will change behavior immediately if you do it that way.
Hit the coaching salaries.
Absolutely.
Oh, I like that a lot. Here's one that here's another case that sort of drew my interest, all right? High school in Ohio, all right? Former players at this high school in Ohio where is it? Okay. They have filed a federal lawsuit against their former high school coaches for essentially being verbally abusive, for calling them bad names, for saying you need to get out there and play even if you're injured. As I said to you in the note I sent to you, couldn't we all file lawsuits against our former high school coaches for being verbally abusive?
How about Pop Warner?
Yeah, and Pop Warner coaches.
I mean, my son played football recently, and the coach was dropping F-bombs. They're 12, 13-year-olds. Yeah, I mean, so this is – I can't even begin to fathom this lawsuit being filed and argued in court.
Especially in Ohio, where they take their high school football very seriously.
Very seriously. It's a very interesting read into some of the allegations, because I thought back, well, I guess I could have had a lawsuit for it, but it was part of the game, and you understood it, and it was supposed to create mental toughness in you.
Seriously, our high school coach, I mean, this was back in the days before you knew that water was good for you. Our high school coach would not let us drink water for the course of the practice because he thought that toughened us up.
Yeah, it's crazy. It's crazy to think that happened and may still happen in some places. Who knows?
I'm sure it does. So,
I mean, it's a very difficult case for the plaintiffs to prove, because they're asking for emotional damages. Mm-hmm. So these players are going to have to bring in experts, psychologists, to say that somehow their life has been diminished. They've suffered emotional distress, and it's a direct result of what the coaches were saying or putting them through. It's a very difficult standard to meet.
Is there a legal line though, like? Okay, this is just old school coaching, and once you cross that line, then it becomes legally abusive.
It's intentional infliction of emotional distress. So you're doing it to cause emotional distress. And
what if you're doing it to toughen them up?
Right, and that would be the defense, and then a jury would have to decide whether they specifically singled out these players and it was an attack on them rather than just football coaching in general trying to toughen up a team. And I can't even imagine bringing that sort of case as an attorney, because there's so many ways that it could go wrong for you.
Although I got to thinking about this when I was sending you a note yesterday, isn't the NFL essentially going through this same sort of thing in the fact that, all these concussion lawsuits, wasn't the coaches and management wanting the players to get out there and play no matter what, and the players thought they were being abused and exploited?
I mean, I guess you could draw some sort of parallels there, but there's a big difference between, playing someone that has head injuries and playing someone who's being told they're not good enough or not tough enough or whatever. It's just words versus an actual medical condition is a pretty big distinction.
So you're thinking you're siding with the high school on this one.
I actually am. I guess I'm old fashioned that way.
You're a sports guy.
Well, I think it toughens you up. I do.
Did you play high school football?
I did.
Yeah.
And with a coach that never swore, Larry Gergely from Winter Park
High
School. The epitome of morality and do things right by the book. I always remember he had a rule: be where you're supposed to be and do what you're supposed to do, and the rest of your life will be very easy.
See, you still remember that. I still remember things my old cranky, abusive high school coach used to tell me. Yeah.
Can you repeat it on the air?
He used to always say, we would be doing our drills as you know, we're thirsting for water that he wouldn't let us have. And then we'd be doing these drills where we'd have to lay on the ground and hold our feet up in the air. All right?
Yes.
Forever and ever. And he goes, 30 more seconds. You can do anything for 30 seconds. You can withstand any sort of pain for 30 seconds. Water.
Unbelievable.
Rick Calzada from My Law Solution. They just opened their new office in Baldwin Park. Rick, of course, is my lawyer, so let My Law Solution be your law solution. Give him a call at 407-843-2222 or online at mylawsolution.com. Rick, as always, we appreciate it.
See the Mikey Awards.
That's right. The Mikey Awards tomorrow, 5 to 7 at Dubs Dread Golf Course, the iconic Tap Room Restaurant. Up